So here's the situation. You're in the US, you're in deportation proceedings, and you're married to a US citizen. What options do you have available? Hey guys, today's video is gonna be a little bit complicated. We're gonna be diving into the weeds of immigration law, specifically the intersection between USCIS and immigration court when someone is being deported and is also married to a US citizen and is trying to figure out what options they have available to them. So whether you just wanna be bored out of your mind or you're an immigration nerd and wanna hear someone go crazy talking about immigration law, or this is a situation that applies directly to you, stay tuned for the video and maybe you'll learn something. Okay, so I'm gonna talk about a couple different scenarios here, but this is the first thing I check for. The first thing I do is I figure out whether USCIS or the immigration judge has jurisdiction over a green card application. Okay, so here's the situation. You're in the US, you're in deportation proceedings, and you're married to a US citizen. What options do you have available? So the first thing I'm gonna do as the attorney is I'm gonna read the notice to appear. The notice to appear is the charging document that says you're deportable. It explains the basis for deportation, what the government's factual allegations are, and the section of code under which you're deportable. It also says when your future court date is and a couple other pieces of information. One of the things that it says at the top of this document is whether or not you are an arriving alien. Most people in this situation are not arriving aliens, but if you are an arriving alien, then you could still file your adjustment of status application with USCIS even though immigration court proceedings are pending. So here's the rule. USCIS has jurisdiction. They have the exclusive power over reviewing I-485 green card applications. They are the only ones who can do it, except when you are in removal proceedings. In that case, the immigration judge is the only one with power. And the only exception from that is if you're an arriving alien. So if you're in deportation proceedings and you are an arriving alien, you can file your green card application with USCIS and you don't need to file it with the immigration judge. But if you're not an arriving alien, then you would have to file it directly with the immigration judge or have your deportation proceedings terminated so that USCIS regains the authority, the jurisdiction to review a green card application. So in that situation, we're trying to figure out who has jurisdiction for a green card application, the judge or the USCIS agency. If USCIS has jurisdiction, which means you're an arriving alien, in that case, I would immediately file an adjustment of status application with USCIS. Guys, by the way, this is a very technical video. Don't just go ahead and do these things without talking to a lawyer. When I say I would go ahead and file it, I would also make sure that the person qualifies for permanent residence, which means they've been admitted or paroled, don't have disqualifying crimes, fraud, or any other inadmissibility issues. So just keep that in mind. I'm talking in very general terms here. But if someone was paroled into the US, they're in deportation proceedings, and they're charged as an arriving alien, in that case, I would basically try to delay deportation proceedings. In parallel, I would file an adjustment of status package with USCIS, which right now would process pretty quickly if it's a marriage-based adjustment. In 3 or 4 months, they might be a permanent resident. And then I would then inform the immigration court, hey, my client adjusted status, they're no longer deportable. I'm gonna file a motion or a request to terminate deportation proceedings. And then my client's good. At that point, they're a permanent resident, they're no longer being deported, everything got fixed, everyone's happy. But oftentimes the cases aren't that clean, which means they weren't paroled or entered legally, and they are not an arriving alien. And those situations are more complicated because we have to file things with the immigration court and USCIS and communicate with both of them and kind of be the middleman between these different agencies until we get a favorable outcome for our clients. So if someone entered illegally or without inspection and was not paroled, and now they're in deportation proceedings and married to a US citizen, this situation is kind of complicated, and it comes down to which court you're dealing with because there are different policies at play. So in every situation, the first thing we would do is file an I-130 petition. We would have the US citizen spouse file an I-130 petition for the immigrant spouse who's in deportation proceedings. And then it depends on which court you're dealing with. The next step really depends. In fact, we have a court hearing today for someone who entered without inspection, is married to a US citizen, and we have an I-130 pending. And what's gonna happen is we're gonna go to the judge today in a few hours, and we're gonna see how the judge wants to proceed with a case like this. What we would love is for the judge to terminate deportation proceedings, so we don't need to deal with immigration court anymore. Some judges will terminate deportation proceedings if you just show them that you have a pending I-130 petition. These tend to be the more liberal judges in more liberal jurisdictions. It's definitely not the rule. It's definitely the exception, but it is possible. So that would be like the first strategy. The second strategy would be to just delay the deportation proceedings until that I-130 gets approved, because once that I-130 gets approved, we'll have some additional options available. The way to delay would be either to request a long continuance. Most judges are less likely to grant those under the current administration. Another thing we could apply for is called administrative closure, which kind of just pauses the deportation proceedings. It's going to depend on which court you're in and which judge you're dealing with. And then the third option, which is not the best, would be to just submit an application for relief, even a possibly weak application for relief, like an asylum application. Get a future hearing date scheduled, like 1 to 4 years in the future, depending on which court you're dealing with, and then hope your I-130 petition gets approved before that final hearing date. Once your I-130 petition gets approved, then it's going to depend on a couple different situations. You can either file the I-485, which is the green card application, to adjust status directly with the immigration judge, and then the judge is going to schedule a final hearing to make a decision on that. But you can only file the I-485 with the immigration judge if you've been admitted or paroled, or you qualify for one of the exceptions like 245I. Otherwise, you're not going to be eligible for adjustment of status. And what you'll need to do after your I-130 gets approved is you'll need to file the 601A waiver for unlawful presence, because you're going to eventually have to go to your consulate abroad to go to an immigrant visa interview, and then you could re-enter the US as a permanent resident. So in this situation, we file the I-130, we buy time with the immigration court. There's going to be an I-130 interview. You and your spouse will attend an I-130 interview with USCIS while immigration court is still pending in the background. Then we're going to probably immediately file an I-601A waiver to waive your unlawful presence. We're going to file that with USCIS while immigration court is pending in the background. That's going to take like 3 years to get approved. After that gets approved, we're going to schedule for your consulate interview in your country abroad. And then once your consulate interview is scheduled, we'll ask the judge, the immigration court, which is still pending, to grant voluntary departure. The judge will grant voluntary departure. You have like 90 days to leave. You leave during those 90 days and you avoid a deportation order. Since your 601A waiver already got approved, you now have no unlawful presence bar. You would attend your interview abroad. If all goes well, you get your immigrant visa, and now you re-enter the US as a permanent resident. All right, guys, if that didn't make your head explode, you are a rare breed of human being, or just an immigration nerd like me. But anyway, I just wanted to give you guys an explanation of what the possible outcomes can be when you're in deportation proceedings and married to a US citizen. If you haven't figured it out right now, this is very fact specific. I tried my best in like a 10-minute video to explain a bunch of different scenarios and what the legal considerations are, but these are some of the more complex cases I have. And to be honest, I really struggle to explain these legal complexities to clients during my consultations, so I thought I would give a shot at it in a video. I'm not sure I succeeded in making this any easier to understand, but for people who already have like a 50% understanding of some of these things, this video might have made sense to you. All right, guys, if you're going through this process or you need an immigration lawyer, you should reach out to me, Puyan Darian. I'm an immigration attorney and I handle family-based immigration, naturalization, and deportation cases nationwide. So if you're dealing with any of these issues, or you want to consult with a lawyer or hire someone, you should find my information to book a consultation in the video description below, or you can call my office or go to darianlaw.com to schedule a consultation. Thanks for watching, and I'll see you guys next time for another video.